Good afternoon, and thank you all for joining us. I am Sebastian Burka, the Acting Director of the Stigler Center, and today we are very happy to host Professors Francis Fukuyama, Nolan McCarty, and Zephyr Teachout for a conversation moderated by Leah and Nylen on whether antitrust should be designed to promote political liberty. Before we begin, please note, we are on the record and we will post the video on our YouTube channel later. If you have questions for the speakers, we will address them in the last 15 minutes or so, and you can submit them via the Q&A icon at the bottom of your screens. As usual, views expressed by guests are their own, not those of the Stigler Center or the University of Chicago. We hope that you will join us for more upcoming webinars, so please check our website as well as our publication promarket.org and our Capitalism podcast. And now, please allow me to briefly introduce our speakers. Their full bios are available on our website. Francis Fukuyama is a professor of political science and Olivier Nomellini Senior Fellow at Stanford's Freeman Spogli Institute for International Studies. His most recent book is Identity, the Demand for Dignity and the Politics of Resentment. Nolan McCarty is the Susan Dodd Brown Professor of Politics and Public Affairs at Princeton University, and he was chair of the Subcommittee on Politics of the Stigler Center Committee on Digital Platforms, whose final report was released in 2019, and we want to thank him again for his contribution. Zephyr Teachout is an associate professor of law at Fordham University, and her most recent book, Break 'em Up, Recovering Our Freedom from Big Tech and Big Money, was released last year. Finally, Leah Nylen, our moderator, is a technology reporter who covers antitrust and investigations for Politico. Previously, she covered antitrust at MLEX and Bloomberg, among others. And now, without further ado, I turn it over to our speakers. Thank you.
Thank you, Sebastian. I'm Leah Nylen, Politico's antitrust reporter, and good afternoon to you all. Thank you for joining us. So this is how it's going to work today. Each of our panelists is going to give about a 10-minute overview with some thoughts. We're going to have a discussion among ourselves for about 30 minutes. And then we're going to leave about 15 minutes at the end for audience questions. So if you have any questions, please feel free to submit them in the Q&A box at the bottom of your screen. To start us off, go ahead, Nolan.
Great. It's really a great pleasure to be on this panel. I thank the Stigler Center for inviting me. Let me start with a couple of disclaimers, not disclaimers about antitrust consulting. I haven't done any of that. But a disclaimer that I'm far from an expert on antitrust or competition policy. Rather, I'm a political scientist who's long been concerned with the connections between economic inequality and the performance of American democracy. An important component of that research, of course, is how economic power translates into political power and how inequality in economics generates inequality in politics and vice versa. So I take as a first premise for this panel that to the extent to which economic power can translate into political inequality, I take that as grounds for measures to limit such economic concentration. So my answer to the question posed by this panel is a conditional yes. But there is one problem as I see it, and that is that our knowledge and thinking about how economic power and political power intersects is not often specific enough to formulate policy approaches and legal rules. So I'm going to make this argument with a couple of examples of projects that I've been involved in. The first was the thing that Sebastian just mentioned, which was that I headed the politics subcommittee of the Stigler Center Digital Media Project. Our group, of course, focused on the politics of digital media concentration. And we really grappled with 4 interrelated facts. The first was that digital media had become an essential part of the political infrastructure of the United States, as well as many other countries. That it had become a primary source of political engagement, mobilization, information, and campaign advertising. But the second point, the operation of these platforms has also contributed to several political harms, including but not limited to misinformation, polarization, hate speech, and harassment. One of the things that complicates the situation and our proposals is that we determined that these companies, especially the ones that are most politically relevant, part of the political infrastructure, are extremely powerful and in ways in which are exacerbated by the political functions that they serve. Needless to say, the big platforms like Google and Facebook have economic power, which almost always directly translates into something like political power. But they also have a quasi-media role. They're very interconnected with their consumers, clients, users. Case of things like Uber, their workers, which makes it much more like a political membership organization like the National Rifle Association or the AARP. And not to mention the fact that they're considered national champions in the kind of international arms race in digital technology and artificial intelligence. So they have a very privileged, political position, yet they are these kind of central political actors. And then the fourth issue we dealt with, of course, was that the economic concentration in the sector seemed to exacerbate these problems. They're not good alternative choices for the political uses of social media other than the major platforms. But the problem our committee faced is it was difficult to see what could be done, or at least it was difficult for us, a fairly heterogeneous group of political scientists and law professors to agree on what could be done. Some of the recommendations seemed easy, like unwinding acquisitions of Facebook, like Instagram and WhatsApp, or YouTube from Google. Some of the proposals that were out there were much more uncertain and we couldn't agree to, like reforming platform liability, a la Section 230. And finally, I think most relevant to this panel, we did not go so far as to recommending stronger measures like breaking up Facebook or Google. This was largely because we didn't know whether or not such a change would improve the political performance of the platforms. We left it to the economists to talk about the economic consequences of breaking up or not, and the privacy experts to talk about privacy. But we couldn't convince ourselves that the political problems of the platforms could be solved. In particular, we worried that network externalities would just lead to reconcentration, an issue I think Francis may talk about in his comments. And then we wondered whether or not competing platforms would compete on the right things in terms of the political role of the platforms. Would they compete on moderation, privacy, free speech, et cetera, the kind of political things. And finally, I think a bigger concern was whether or not fragmentation of these online communities would just make it easier for extremist communities to operate out of sight. And so in the end, we felt that we wanted to make recommendations, and so we went more in a direction of more regulation of these platforms, but not necessarily breaking them up. So we made several recommendations focused on regulation, transparency, allowing third parties access to algorithms for algorithmic audits, and other things to help develop policies which can minimize the political externalities imposed by these platforms. Okay, so that's one. So that's one example, where it come to the conclusion we don't really. There's a big concern, no doubt, but we didn't really know enough to do something about it. So let me say a few words about a second project. This is a project ongoing with Zephyr Teachout of Fordham Law School. And the emphasis of this research is that broadly some basic questions which might be required to take political inequality into account when formulating antitrust and competition policy. These questions include: what is the relationship between economic concentration and the political activities and influences of firms? What is the relationship between firm size and lobbying activity? What is the relationship between industry concentration and lobbying activity at both the firm and industry level? And whether or not mergers and acquisitions increase the political power of surviving firms by eliminating political competitors. One example is, at least during Glass-Steagall, There was a lot of conflict between insurance, commercial banking, and investment banking when they were separate industries, but there's not that same contestation now that they're all consolidated financial firms. But what we discovered is that as important as these questions are, there was almost no research attempting to answer them in kind of an empirical way. So we have a project, it's new, and it's been beset by some kind of severe data challenges in linking firm and industry data to political lobbying data, but there are a few early takeaways. The first is that, contrary to the view that economic power and political power are tightly intertwined, we find the relationship between firm size and the political activity of firms is not as strong as people would believe. So for example, of the Fortune 100, only about 20 or 30 of those firms are among the top 100 lobbying firms. Okay, so the overlap between the biggest lobbyists and the biggest firms is not that great. We find that the political expenditures of an industry is far less concentrated than firm revenues. So we don't find that the political activities are more focused on the dominant firms than the industry is in itself. We find that levels of economic and political concentration are not positively correlated, as kind of at least a naive view would have it. And this sort of is independent of how we measure economic and firm concentration. In fact, some of the multivariate models, we find a negative correlation between political and economic concentration, such that there's more diversity in the political behaviors of less concentrated industries than there is of more concentrated industries than there is of more economically concentrated industries. So just to wrap up here, admittedly, we've been looking at a fairly narrow set of political behaviors and nothing yet about influence. Obviously, the second phase of firm power is very important, as is the structural power of firms, that is the deference that politicians give firms because of their role in maintaining good economic performance. But at least it's, the results are kind of interesting in the sense that we would at least expect lobbying activities to be complements to these structural powers rather than substitutes. And it's striking that we're not finding a particularly strong relationship between the concentration of economic markets and the concentration of political markets. So I still think the answer to the panel is yes, but I would argue that a lot more work needs to go into how to make antitrust responsive to the issues of political liberty. Okay.
Great, thank you, Nolan. So, Francis, I think you're.
Yep. Okay. Thank you. Grateful to the Stigler Center for inviting me back again. What I say is going to reflect a report that of the Stanford Working Group on Platform Scale. We actually started out as the Stanford Working Group on Antitrust, but we decided that antitrust was actually not the appropriate framing for the problem that we had identified. So that gives you a preview of what my answer to the question is. I actually don't think that antitrust is the right instrument to protect political liberty. I think we have to begin by thinking very clearly about what the harms are that the internet creates for democracy, the political harms as opposed to the economic ones. I do not think that the existence of fake news and conspiracy theories is the central, that stamping these out should be the object of public policy. Unfortunately, these things exist out there in society, but in fact, their expression is protected by the First Amendment. All democracies believe in freedom of speech, and so the expression of extreme views is, legally protected. Obviously, not incitement to violence, not conspiracies to overthrow the government, but the simple holding of unpleasant opinions is not what public policy should be aiming to shut down. I think that the real threat is the artificial amplification or the silencing of particular political speech and particular political actors. I think that these fringe theories or conspiracy theories become really dangerous when they get picked up by the mainstream media or they go viral on the internet and get introduced to a much larger audience that potentially has the effect of, for example, influencing a democratic election. And so it's really the scale of the platforms and their ability to do that, either amplification or silencing, that really should be the object of policy. Let me just give you a quick example of that. There's a really fascinating article, I can put this in the chat, in the British Wired magazine by a reporter that was saying that QAnon had succeeded in invading her yoga forum. And apparently this has been happening to yoga forums all over the world, where people start putting information about, harms from the anti-vaxxers, and the QAnon types have basically told all of these, a lot of them are mothers raising children, that their children are really subject to pedophile conspiracies from Washington and so forth. And I think that's an example of what the platforms can do that a smaller platform like Parler, or one of the ones that a lot of the right-wing groups have migrated to, cannot do, because you have to actually go and seek those platforms out if you want to communicate with your fellow conspiracists. And what the established platforms do is make it possible to break out of that ghetto, so to speak, and reach much larger audiences. And this is really, I think, the central problem we have to deal with. The solution that we have in front of us right now is basically self-regulation, giving the power to the platforms to curate content. We just had this decision in the past day by this so-called Facebook court about its content curation policies. But I think we have to understand that, except in the short run, this is simply not a sustainable solution for a democracy, this kind of self-regulation, because there's basically no legitimacy to this. There's nothing that gives Facebook, the enormous power to make these politically consequential decisions as to what is acceptable political speech and what is not. And I think the Twitter deplatforming of former President Trump is a good example of that. I personally supported that decision as a short-run solution, but it does underline the enormous power that Twitter has over political speech in the United States. And that, I think, should worry people regardless of what they think about, the particular use of that platform by a particular political actor. I would say, just finally, the other problem is that the information you get over the platforms right now is determined by them. It's determined by completely non-transparent algorithms over which you have, or individual users have, virtually no control. And that in itself, I think, poses a big agency problem. Now, in terms of solutions, antitrust could be a solution if you actually went for something like structural breakup, because if the problem is scale, if somehow the platforms were made a lot smaller, they would be less able to influence our politics. I do think, as Nolan suggested, that this is really pretty unrealistic. It's time consuming. It would take a decade to get to a decision like this. And then the network externalities, I think, probably mean that you'd have a baby Facebook that would occupy the position of the parent Facebook very, very quickly, much more quickly than the time it took AT&T to resume its dominant position in the telecoms market. And I think the other antitrust remedies that are out there, like, prohibiting acquisition of startups or prohibiting various forms of tying, vertical tying, and so forth, will address specific economic harms. They will not get at this control over political speech that I think is the central issue that we should be worried about. Antitrust law has evolved to address economic harms in terms of consumer welfare. There is a neo-Brandeisian school out there that would like to inject political objectives into antitrust law. We don't favor this particularly because I think that it, first of all, leads to an incoherent policy. It's going to make courts have to come to decisions resolving incommensurable goods, political democracy as opposed to economic efficiency with no real guidelines as to how to do this. And it also opens up the door to the politicization of antitrust law. And I think we saw some examples of this, like when the Trump administration tried to intervene in the AT&T acquisition of Time Warner for what I think were fairly suspect political reasons. So basically, I think antitrust is something that should be pursued, but it should be pursued to remedy economic harms and not the political ones that I've stated. There's several other possibilities. You can use privacy law to get at to limit the underlying power of the platforms who have developed this enormous data sets that can be used in various domains, which really makes online markets very different from earlier forms of markets. I think GDPR in Europe tries to do that, but it's been very, very difficult to enforce for a whole variety of reasons. Data portability has been another suggested solution to increase competition for reasons that I can get into in the Q&A. I just don't think that that's going to work because I think the data is very platform specific and there's a lot of legal questions over the ownership of metadata that would make this very difficult to enforce. We suggest a solution which we call middleware, which would essentially be software that sits between the user and the platform that gives the user control over what they see and hear from the platforms. There are different ways of implementing this, but what we would envision is a competitive layer of middleware companies that could, to which the platforms could outsource content curation. It would restore competition in this sector, which is now dominated by basically, three large platforms, Facebook, Google, and Twitter. There's a lot of technical issues about the business model, about the opening up of the APIs of the platforms and how this would be accomplished. We don't have answers to exactly how any of this would work, but it's our view that this is one of the more practical ways of moving forward at getting at the underlying problem, which is platform power, this power to amplify or to silence, because I do think that that is the major threat that they pose to our democracy. So, thank you.
Great, thank you. Zephyr.
Well, thank you for having me and thank you for such a rich discussion. It's so hard not to immediately engage because what I hear Francis saying is that he doesn't think antitrust is the solution and then proposing an antitrust solution. So we may be having some semantic debates. And I say that seriously because I think there are in the background of we're at a moment where there's very rich and critical debates about the shape of economic and political power. And I do think not infrequently, people speak past each other because of different definitional understandings of highly contested words like antitrust and anti-monopoly, both of which have been keywords, to use a sociological term, among the most contested, certainly in American history. So I start with the same position that the Constitution of Maryland or the Constitution of Utah did in the 1880s, saying monopolies are odious, contrary to the spirit of a free government and the principles of commerce, and ought not be suffered. And although the question today is one about antitrust, I want to start with suggesting that Francis said there are Brandeisians out there. I guess I'm one of those Brandeisians out there. That there is a growing movement, which I'm very happy to be a part of, but we largely talk about it in terms of an anti-monopoly movement of which antitrust is a central but not solitary tool. And the anti-monopoly vision is grounded in a vision that democratic freedom depends upon not allowing private power to take on a kind of governing role in a democratic society. And that leads then to two solutions when one confronts governing private power. Either break up, that is the antitrust solution, or regulation, which can come in varying degrees, from nationalization to what you might think of as public utility regulation, a high degree of public governance, to common carriage, or a set of principles saying, if you are going to play this governing role, like the railroads did in the 1890s, you then, and be setting prices, setting the terms of engagement, governing significant parts of our society, then you must be subject to certain principles, including the principles, most importantly, of non-discrimination. So I want to briefly suggest the family of laws that come within the anti-monopoly ambit. So we see them in relationship to each other and recognize that antitrust is a key, again, but not sole actor. And if we see it as a sole actor, I think we miss its important role in this sphere of laws. Francis mentioned privacy law. That's quite critical. Agency law, you know, how, where liability and responsibility relate to each other. Arbitration law, which we're probably not going to talk about today, but allowing private forms of law creation and dispute resolution is, I would argue, at the heart of our current monopoly problem. So allowing forms of private governance, certainly corporate law, campaign finance law, labor law, tort law, procurement law, trade. All of those are part of an anti-monopoly toolkit, kinds of things that you want to think about if you, like the Maryland or Utah state, think monopolies are odious and contrary to the spirit of a free government. So the two key tools, however, are antitrust and what I'm going to call common carriage for now, but it stands for this set of sort of non-discrimination regimes. You know, some people might use public utilities as stand-in. And so when we're thinking about that, it's two kinds of breakup regimes and then a set of behaviors, kinds of contracts that are illegal that allow for the concentration of power outside the boundaries of the firm. So the breakup that people tend to think of, and I realize this is the error in my book's name, is that people have a default thinking, it's called Break 'em Up, of thinking about breakups as horizontal breakups, and they're very important. So the horizontal breakup that I think both of you have just endorsed in the name of political liberty is Facebook and Instagram, Facebook and WhatsApp, like separating from like, two shoe companies separating from each other. Vertical breakups are arguably just as important. So this is where, and since we're talking about big tech, I think it's really important to be thinking about the breakup between, say, Google and YouTube, Google and Google Shopping, Google and Google Flights, Facebook and Messenger, Amazon, the platform that allows sellers and buyers to come together, and the warehouses the distribution networks, which Amazon currently uses a series of very aggressive, I would argue illegal, incentives to force its sellers to use, but owns warehouses. So breaking up Amazon, the seller, from Amazon, the warehouses, would be a classic vertical kind of breakup, key tools. And then the third tool is the common carriage tool, which is to say, there are going to be instances where we as a political society decide that there are enormous benefits. And I do think this is a political and democratic question, enormous benefits to the network. To having one or five, it doesn't have to be just one, but not infinite number, not complete competition. And so we want actually to have just a few, maybe 5 places we go to for social media. And therefore, because we are so worried about the democratic risks of 5 little Zuckerbergs deciding the shape of our speech. And I share Francis's deep concerns about the democratic concerns of concentrated, arbitrary political speech power that we have right now. That you also then impose common carriage kinds of regulations, non-discrimination kinds of regulations. And the few minutes I have left in this introduction, the other framework I want to set up is just have in the back of our mind the kinds of democratic harms that flow from concentration. I'm really interested in digging into Nolan's research. I was even starting to poke around online as he was speaking because I want to get into the weeds a bit. But the one that we most often think of is the kind of the political harms of concentration, is the kind of harm that Nolan is looking at, where we look at sort of pretty blunt, direct purchase of political power and influence through lobbying. And he rightly highlighted that they haven't yet looked, and I'm really eager to see where they look next, at the other forms of influence buying, like think tanks, universities, and media, and other forms of what you might think of as soft power in the corporate space, swamping the cocktail parties in DC with not necessarily paying people to go to the cocktail parties, but the fact that they're there shapes the conversation. So that's the kind that I think is incredibly important, and we should look at. And I'm probably a little less worried than Nolan is, although it may not be, about an imperfect match there, because there's enough evidence that it's one of the key tools that concentrated power uses to maintain and extend its forms of private governance and monopoly control. But I think the research is really, really exciting. But there are other forms of democratic harms. The one that Francis is really focusing on is he mentioned 2, but there are 5 real democratic harms that come from our current social media framework. One is concentration and arbitrary power, a lack of transparency. Another is the way in which it actively promotes, as Francis was talking about. It doesn't just allow, it's not sort of a passively allowing, but actively promoting the highest conflict content. I often think of it as, like, if we allowed public libraries to use the business model that Facebook did, you'd have just porn and white nationalism up front, and the librarians would be encouraging you to yell because they'd want to maximize the time you spent in the library. There's a privacy harm with our current business model, which is that it's highly intrusive. And then there's a democratic harm in that it treats all of us individually. So there's significant democratic harms in our media environment. There are democratic harms that flow from the economic inequality that Nolan was talking about. There's a lot of evidence that the last 40 years of concentration, the 500,000 mergers that we have allowed, and the rapid consolidation in industry after industry has been a major driver of suppressing worker wages and increasing inequality and increasing the wealth of the investor class, not leading to greater investments. And that inequality has a democratic cost. there is a racial cost that we haven't talked about. Along with the last 40 years of concentration, mergers have a racial component. You've seen the wipeout of industries and locuses of Black power, Black insurance industries, Black banking, Black pharmacies. I ask people to imagine what the civil rights movement would look like today when instead of Black-owned cars for hire, you have centralized companies like Uber that actually decentralized locuses of economic power have actually been very important for communities of color having economic power. So there is a political cost to that as well. I mentioned arbitration. And then the last is sort of the first, which is that for most of American history until the 1980s, we understood that we should have a functional, not formal approach to what constitutes government. And that these companies at a certain scale, and it's not always easy to tell when that moment is reached, start to really play a governing role. And they are governing without even the defense, the monarchist defense of Hobbes behind them. They're governing without any legitimate political theory to justify their power. And when you see companies like Amazon that is not just treating its own warehouse workers badly, but effectively setting the terms for what it means to be a delivery driver because of its incredible power over those from whom it purchases services from, that is a governing role. It is acting, when you see Facebook effectively acting as our national privacy commissioner, making decisions about the scope of our privacy, that is a governing role. And again, it's not always easy to say that that's the point where it moves from private to public. But we all know that at some point, when there's the rich man behind the mayor in a town, we would call him functionally the mayor. And we have to understand that these companies at a certain scale and choke point power threaten democracy because they are a replacement for the whole operating system. And this is why antitrust, as part of the whole anti-monopoly arsenal, is critical. Because although it may not, there may be, as the economists like to say, some false positives, the democratic risks of allowing these companies to govern us with arbitrary concentrated power in a way that drives inequality is really quite significant. So I look forward to having the discussion about the platform problem and particular proposals. My own proposal is a combination of horizontal, vertical breakups and a common carriage regime for a sort of non-discrimination regime for social medias with strong network effects. I think that's really essential. And this is why bringing the toolkit together is important. But I do not think this is only a tech problem. It is actually a democratic problem that encompasses but is not limited to tech. Thanks.
Great. Thank you so much, Zephyr, Francis, and Nolan, for those great introductions. Just as a reminder to everyone, we're going to have a chat now for about the next 25 minutes. And then at 2 o'clock, I'm going to switch over to audience questions. We already have a bunch of really good ones. But if you want to add some more, go down to the bottom of your screen where it's the Q&A thing. Just type it in. It comes right to me, and I will read those out starting at 2:15. Okay, so I actually want to start with something that Zephyr said, which is today, when people say the word antitrust, they sometimes mean completely different things. So I thought that would be a very good way to start. What do you think the purpose of antitrust laws are, and what do you think they should be? I think, Zephyr sort of talked about this quite a bit. So why don't Francis and Nolan, why don't you guys start with that one?
All right, well, let me begin. I think that you have to look at this historically. So I think that the Sherman Act actually was meant to encompass both political and economic aims to ensure economic competition, but also to prevent the sorts of harms that both Nolan and Zephyr talked about from that kind of concentrated economic power. Then with the rise of the Chicago School and George Stigler and Robert Bork and other U of C economists and legal theorists. That function got narrowed to economics, and within economics, it became narrowed to consumer welfare. And that's really what's governed the law since then. I do think that as a theoretical matter, that is too narrow a focus. And there are many other political objectives that the law could address. I do think, however, that it is rather, it gets very tricky when you think through how you're going to balance the political objectives against other. Let me just give you an example. If you abandon consumer welfare as the standard, which I think some early antitrust cases did, they wanted to protect small producers. That essentially puts a judge in the position of having to adjudicate a kind of zero-sum contest for consumer surplus between producers and consumers. And the one nice thing about the Bork consumer welfare standard is it gave the judges a pretty clear indicator. But if you remove that and say, well, we also want to protect small producers, how small, which producers, is it the result of lobbying by particular groups of small producers and the like. And that's why I think that there's a certain logic to having, strictly speaking, antitrust law focus on those economic harms. And by the way, I agree completely with Zephyr. There's many other approaches, the vertical tying and vertical acquisitions have really, had a lot of deleterious consequences. But I do think that it's kind of a definitional matter when you start bringing in other approaches like, privacy, portability. You're kind of getting out of the realm of what's traditionally understood as antitrust. And I think there's probably some conceptual virtue to keeping those, different types of law separate, even though the objective may be the same, which is to reduce the power of these big companies.
Yeah, that's really interesting. The example you're giving is exactly the Amazon problem, right? Amazon, everybody says, is great for consumers because it gives you low prices, it gets you things quickly. But as we've seen from the House report, it doesn't always treat its smaller businesses who use the platform very nicely. Nolan, I know you said that you're not an expert on antitrust law, but what do you think the purpose of antitrust law is?
I'm just going to give you a reminder of that. I do broadly supportive with kind of a broader conception of antitrust and anti-monopoly. I think part of the issue is not so much that antitrust is evolved in this narrowly economic sense, but even within economics, a very narrow economic sense on consumer welfare and prices. It ignores the problems of size and concentration, on the fairness in two-sided markets, and most importantly, ignores the impact of monopoly power on workers. So I think you can actually go a long way with antitrust, and even dealing with some of the political problems that Zephyr mentioned, simply by taking more seriously a role of antitrust, and dealing with the small sellers at Amazon, dealing with workers, making sure that employers can't collude to fix wages, non-compete contracts, all of those things. And that'll solve a lot, I think, of the what Zephyr's calling the kind of governmental power problem of monopoly. I am, as I said, open to a broader conception which tackles the more transparently political aspects of monopoly. I just think we know less about how exactly to design policies to do that. But like Francis and Zephyr, I think that current antitrust is too narrow. You can do a lot, even within the economic sphere, to solve some of these problems. And then, I'm open to some political interventions as well.
Okay, great. So there was a recent, go ahead, Zephyr.
Quickly engage, because I think there's some really important points that I want to highlight here. Many, of course, but one is that the history that Francis gave is really important. And anti-monopoly law precedes antitrust law. And I think it's fair to say that you see anti-monopoly law and early corporate law, and then you see what we think of as antitrust law beginning with the Sherman Act. And the Sherman Act is quasi-constitutional in its brevity. It effectively says no monopolies, and then that has been left up to courts and enforcers to define. And up until the 1970s, the way in which courts and enforcers understood that was through a structural lens, which is to say, we are going to not allow there to be less than 6, 5, 7, major competitors in a market. And if there's fewer than that, and there's language in these antitrust laws, which are a subset of anti-monopoly laws, that is prophylactic, that says, even if it will tend to create a monopoly, we should be hesitant about it. So for many years, enforcers said, what that means is we need what looks like a competitive market, 6 or 7, 4 or 5, actual competitors. The shift to the consumer welfare model that you see in the late 70s and 80s has taken this constitutional in its broadness and vagueness and inserted consumer welfare in. I would say it's pretty weak history and weak as a democratic matter, because this doesn't come from the public coming together and insisting on a consumer welfare standard. In fact, I think one of the great political losses is we used to see a lot of political legislation and the public engaging in these questions. And I think that's about to happen again, which is very, very exciting. There's some very important research showing the inconsistencies, the internal inconsistencies within the consumer welfare model itself. It isn't always so easy. It sounds clean, a little bit like quid pro quo sounds clean. There's certain language that sounds cleaner than it is in practice. But I take very seriously Francis' point about what you don't want to have is you don't want judges making determinations, sort of unconstrained determinations about, or enforcers about what is a politically dangerous company. That is a sort of a democratically dangerous situation. And so the best rulemaking and lawmaking, both rulemaking, which is possible now, lawmaking, which is possible if Congress acts, would, I believe, constrain in the direction of a structuralist approach. So basically move away from consumer welfare. The purposes are here. The judge's job is not to be engaged in those purposes. The judge's job is to enforce a structuralist approach so that we have, in fact, a greater dispersion of economic power to protect political liberty. So when you hear, speaking of semantics, politicization of antitrust, it can mean 3 things. It can mean antitrust is in Congress, suddenly we're talking about it. It can mean the judge should be making political determinations, which would be a terrible idea. Or it can mean what I'm talking about, which is one of the purposes of antitrust law had always traditionally been an understanding that we should protect against even the possibility of private governance. And so you need a structuralist approach.
Thanks. When I was getting ready for this panel, I went through some of the other ones that Stigler had done in this conference series. And there was one with the Nobel Prize winning economist Paul Romer. And he took issue with something that the American antitrust enforcers love to quote. They always say, big isn't bad, big behaving badly is bad. But he actually rejected that in his, he said, when firms get big enough, it's always bad. And his argument wasn't necessarily focused on the economic efficiencies of that, but he was saying when firms are concentrated, they are inherently going to threaten the rule of law and democracy. I sort of wondered where you guys come up on that. I mean, I think it does fit in a little bit with what Francis was saying. When they are large, the power that they have through amplification is much larger. However, if we were to break them up, we're going to have 5, 6 baby books, whatever, and then the possibilities for content moderation are perhaps smaller. So Francis, why don't you sort of start us off? What do you think of that idea that it's always bad when firms get to a certain size?
Well, yeah, so amplification or silencing that I'm talking about really is purely a function of platform scale. We don't worry about private companies curating content in a certain sector, which is called the media sector, right? So the New York Times and the Wall Street Journal are private firms that curate the content, CNN and MSNBC and so forth. And I think we don't worry about that because they do not have the kind of dominance that the three big internet platforms do, where they could, on their own, actually decide to throw an election if they really, wanted to do that. And that's why I think that increasing competition by reducing scale is really an important remedy. I like the idea of regulating the internet, the public, the common carriage model that Zephyr talked about, and other approaches to that, treating these companies like utilities. I just think that it's hard for Americans to do that. We're not Europeans. I mean, that's the path that both the European Commission and individual European countries have taken. They can do this because they don't have our kind of anti-statist traditions, and they accord much more legitimacy to their government agencies, and especially in Northern Europe, they're just not nearly as polarized as we are. I can't imagine. So I've always thought that the situation of these three big platforms is very much like the three big television networks back in the 1950s and 60s, when we saw fit to impose through the FCC something called the Fairness Doctrine. And in fact, there are calls now to revive an internet version of the Fairness Doctrine and try to regulate them in that fashion. I just think that's completely unrealistic politically. We are so much more polarized today. I mean, the Republicans never liked the Fairness Doctrine, and they eventually got rid of it in the late 1980s. But the idea that we could somehow agree to give the FCC instructions on what is fair and balanced coverage of political news in this current political environment is impossible. You can do it in Germany, you can do it in Sweden. You may still be able to do that in Britain. You cannot do that in the United States. And so therefore, I really do think that, you do need, I mean, if you want to call it structural breakup to at least outsource the content moderation function, I think that, increasing competition through reducing size is the only practical way that we have in the United States of moving forward.
Nolan or Zephyr?
Yeah, I'm inclined to agree that bigness in and of itself is a problem. The opposite premise is that as long as companies are good, they can be big, and then bigness is not a problem. But the nature of being big is the relaxation of the constraints of competition, which means that anything that companies do are in some sense arbitrary, and that the power of the executives and the board. So some people might say it's good that Zuckerberg put in a lot of money trying to reform the Newark public schools. Well, that's still kind of a lack of democratic accountability. He gets to decide how much, he gets to negotiate with the school district as to, what reforms they're going to do and what reforms they're not going to do. And so even when companies that are big and unaccountable try to do good things, it still raises very serious questions about democratic accountability.
And Barry Lynn, who's a great friend of the center, points out something which we haven't talked about, which is the other problem with bigness is fragility, which is a real democratic problem, that when you have a concentrated or a company that is so large and so central to an economy, breaking that actually has really devastating effects, and of course worse effects on people who are poorer and more dependent. So we saw that certainly with the crash of 2008. And I would argue that the crash of 2008 is the beginning of the modern anti-monopoly movement. I feel like my job as a person, but also maybe as an academic, is to propose the solutions that I think are best. And I think we may be at a moment where new solutions are possible. So the way that I have been talking about the common carriage regime is to suggest that we ban a certain business model, targeted ads, behavioral ad business model, or essential communications infrastructure. I don't disagree with you, Francis. That's a hard political lift, but I don't think it's necessarily an impossible one. And when you see the success of the network neutrality movement, which came from the worst, geekiest name movement ever to broad acceptance that that a neutrality regime should be imposed there, I think you really see the seeds of what could also be a move here. Right now, this is outside my expertise, but we're experiencing a moment of the risks of gambling system. There are business models that are not allowed, period, or not allowed in certain forums. And since the beginning of the Republic, the communications infrastructure, the importance of a decentralized and fertile open communications infrastructure has been absolutely central. Once we see social media platforms like Facebook as essential communications infrastructure saying, well, like the telephone, you can actually charge a fee for service as opposed to have a targeted ad business model, is a big shift. It'd be a major shift. But I think it's possible. And interestingly, as Leah knows well, the seeds of that are in the House Antitrust Subcommittee report. I don't have the page number in front of me, but I think it's around page 340. I was very excited to see it in there. Suggested that non-discrimination regimes might be important. Well, what does that look like? It's basically saying you don't have social media that is actively promoting, that is choosing that I see the more toxic material as opposed to being a true platform. And the other reason this is possible, politically possible, is the alternative that is being proposed is to treat these companies as if they are newspaper publishers. And I do take exception to what Francis said earlier, because we have in fact required enormous amount of we give a lot of responsibility to newspaper publishers. Yes, there's a First Amendment, but they are in fact liable in a whole bunch of areas. And so the alternate push we see now is the move towards liability. And to me, that's a more dangerous direction, because it then says we want them to be our editors in chief and also hold them liable, as opposed to there's a huge value to having a neutral platform. There's a cost to the vision that I'm laying out. There's a cost in the neutrality principle. The cost is that I don't get to see those very amazing triple high heels that I have always wanted and never knew that I did, but Facebook knows that I wanted. There is a cost, and I have to see boring pictures of dogs, which don't interest me at all, when I only want to see pictures of cats that Facebook happens to know that I want. So I don't want to say that there's zero cost. I say that lightly, but I want to be honest about it, is that, but it is such a democratic harm to have a targeted ad business model be driving our communications infrastructure that I think it's really important to be actively advocating the alternatives.
So I think that actually makes a pretty good segue into some of the proposals to change antitrust law. As you mentioned, the House Judiciary Committee had a pretty large report that came out in October. If you're not familiar with it, just Google House Judiciary Antitrust Report. I think it's the top thing, but it had a wide variety of, they called it a menu of options, I believe, and it had everything from repealing a bunch of the Supreme Court cases that have made enforcement by enforcers actually a little bit more difficult to some of the things that have come up today, including interoperability and data portability. They suggested creating a Glass-Steagall for the internet, where platforms would not be able to be both the platform and sell on the platform. And I don't remember if they called for a digital regulator, but some other company, they did not call for a digital regulator, but various other countries around the world are actually considering creating some kind of special digital regulator for the internet. So I'd like to talk a little bit about those. I think, Nolan, you had said that you could talk a little bit about what some of the benefits versus drawbacks of creating a digital regulator for tech could be.
Yeah, so in our Stigler report, we spent a lot of time on talking about the design of what a digital regulator would look like. We didn't get into a lot of very, very specific proposals because we saw there are two primitive problems that would need to be solved before it could be effective. One was to design it in such a way that, given that we're concerned about political harms, that it couldn't be politically captured and politically manipulated. So we spent a lot of time dealing with that issue. But the other issue was just simply that to regulate these firms, the regulator was going to have much more information about how the algorithms work, how the platforms work, to help determine what types of algorithmic manipulations would be allowed and which ones weren't. So our focus really is the kind of first step was to give a regulator the sort of powers to force the black boxes open, to create lots of opportunity incentives for academics and third parties to examine and audit those algorithms, to determine, the extent of their biases, the extent to which they create unfair trading practices or unfair political practices. So we didn't prescribe any particular rules that the regulator might formulate, but rather, a regime in which the regulator would have access to much more information and technology by which to better understand the types of manipulations that were taking place in the platform, so as that they could write, better rules in the future.
I also wondered, the Glass-Steagall for the internet idea is very interesting. It's one, some of the Republicans immediately said was a non-starter, but it's one that the Democrats, in particular, David Cicilline, who heads the House Judiciary's Antitrust Subcommittee, said he's interested in pursuing. I know, Zephyr, I think you have some thoughts on that, but I'm also interested if Francis and Nolan have any thoughts about sort of separating those two roles.
Well, I think we did talk about this previously, and I think it's a really powerful and important proposal, and it's the kind of proposal that helps deal with one of the problems Francis was talking about, which is using existing enforcers in individual cases to move forward on breakups. Is that if you have a regulatory regime that says you can't be the platform and also play on the platform, basic conflict of interest principle, both democratic and economic principle, that then will lead to vertical breakups without the need for, you're always going to need these enforcers, but have a default principle as opposed to the after the fact enforcement that we have now. It's quite interesting about the breakup requests of the current AG lawsuits. I just want to, because I know you might as well point out areas of disagreement. I am not supportive of the independent regulatory agency for two reasons. One is that the FTC, well, there's three reasons. The FTC has this power. The FTC has substantial investigative power, and it should use it. And one of the many things the report did is pretty brutally embarrass the regulatory agencies for not doing their jobs. finding out in congressional hearings what the agency should be finding out separately. Second, I think it's not for nothing that Lena Khan, who's been really one of the leaders in explaining antitrust and the particular conflicts that arise in antitrust, actually comes out of both a journalism background and studying ag. That when we look at tech as something that your eyes glaze over and you need to be a tech person to understand, I actually think it can obscure as opposed to illuminate the ways in which the business model is working. And third, because I share Nolan's concerns about capture, you're much more sophisticated than I am on this, Nolan, but the basic rule is the small agency that is specialized gets captured. And so the generalist agency, the FTC, is far less likely to be captured by big tech than a small and specialized agency. My biggest concern is, however, that it is a kind of a punt, that we actually have existing laws, existing proposals, and that in as much as we see people like Fiona Scott Morton, who's worked for Amazon, and others who have deep entanglements with big tech supporting it, it raises a question about whether it is a way to delay, like in a constitutional moment, delaying, well, what's our country's language? We'll leave that to another commission to decide down the line, instead of aggressively taking this political moment to move for regulatory and a legal action that is already there. In some ways, it gets the current regulators off the hook by suggesting they don't have powers that they already have.
Great.
Yeah,
So
it does.
Oh, go ahead.
Yeah, I mean, it does seem to me that we can do both. I mean, we can get the Justice Department and the FTC to actually exercise the powers that they could be exercising, but we could also lay the grounds for a specialized regulator. We've tended to support that. I mean, it's not something we're going to fall on our swords over, but it does seem that there's a lot of precedent in regulatory policy for actually creating a separate institution. The example that I would point to is the ICC, which was the first federal regulator, which was designed to regulate railroads. And when trucking came along and when the airlines came along, well, let's stick with trucking. When trucking came along as in the early 20th century, they said, well, this is something the ICC can do because they regulate transportation. And it turned out that the economics of trucking were completely different from the economics of railroads. And that, I think, in retrospect, was regarded as a big mistake. And so finally, when the airlines came around, they said, okay, this is a form of transportation, but the ICC really doesn't have the capacity to do this. And it's the capacity issue that I think is critical. There's all sorts of very nuanced, both technological and economic kinds of determinations. For example, if you want to prevent acquisition of startups, you have to have some kind of a standard by which you can say, well, this startup could plausibly grow to be the size where it would challenge the platform, and this one has less of a chance. I mean, I'm not sure anybody could develop that kind of predictive power, but there's a whole set of questions, I think, that are really beyond the abilities of the existing regulators to do. And so that would be my case for actually thinking about a more specialized regulatory body.
So I love the ICC. I think it's a wonderful example, but it begs the question of what these companies do. Is Amazon's biggest competitor DHL in warehousing? The language of big tech, I do think, obscures their economic functions. And because they're conglomerate and play so many different roles, it actually confuses it. So I think that the idea of a specialized agency around data or tech is actually one of the sort of key issues here, because it's not around logistics, which is what a lot of what Amazon does. So that is the scope. I do think is a problematic feature, and I love the ICC.
I'm gonna move on to some of our audience questions now. As I said, you guys can still type them in. I will see them. So this one comes from Mark McCarthy. Under a non-discrimination regime, how would platforms deal with hate speech and disinformation? Are you saying they should be required to carry all legal speech? Legal speech can be disruptive, vile, hateful, racist. How could they maintain any civil discourse on their platforms under a non-discrimination regime?
Well, I assume that comes to me. So I would love to hear how Francis and Nolan are thinking about this. Yes. So I think the big problem with current platforms is that they actively promote, not allow, but promote toxic, high conflict content. They are not neutral. The problem is not allowing, but promoting. And this relates actually to, so the business model is the problem. And so if you see the active pushing, now you like this conspiracy, here's another one. There's wonderful reporting on this on both YouTube and Facebook. We've been talking about Facebook, but YouTube has the same business model. And so that if you think that is the core problem, the active pushing towards high conflict, conspiracy conflict, which I do, then addressing the business model and requiring neutrality is the key answer. Yeah, so I think that moves, that's the direction I would move in. And if then you think that there is a problem with our sort of scope of First Amendment, you engage on that front. You could, of course, also have, it's a little complicated, you could have a neutrality regime and a liability regime. My own view is that liability should accompany that which is promoted, not that which is on the platform. So that if somebody comments on my blog post and I'm not engaged in any kind of sorting or curation, I'm not liable for that content. And that, I mean, this is the heart of the debate right now. And that is where I come out.
Yeah, I actually think that you have to have content curation. You know, the internet is such a sewer. If you don't have somebody adjudicating, you know, what's acceptable, it's just going to overwhelm people. And that's why we like our middleware solution, because, for example, you know, one of the suggestions that we make is you could have a coalition of universities that fund an NGO to do content curation for faculty and students at, you know, higher education institutions that would actually point them towards, they would vet and then point them towards reliable sources of information. So if you are doing academic research on the internet, you wouldn't turn up all these ridiculous, you know, self-published sites with no credibility, but there would be some due diligence. Now, that works in the other direction, because conspiracy theorists would come up with their filters that would point people towards, you know, conspiracies. But you should have a choice, and you should be able to say, yes, I don't want to see all this garbage, you know. And in fact, I think there's a practical problem. You know, there's been this suggestion that the platform should just do things chronologically without ordering things. And apparently when that happens, people just can't deal with it, because, you know, just to see things chronologically in a truly neutral fashion, there's so much junk in there that they quickly lose, you know, interest and can't really see what actually is of importance. So that's why I do think you need curation, but you just need to be able to control the curation and make sure that it's the sort that you want and not what the platform has arbitrarily chosen for you.
Can I just clarify? So I think you were saying the platform does no curation.
Right? It would be outsourced. Yeah, the platform would outsource that function
legally. So it's not optional. It's the platform.
Yeah, you'd have to do this by statute. Yeah, you'd have to require them.
So you're actually advocating a far more decentralized, and then you would have thousands of.
Yeah.
And those are ratified by the government, or they just exist, or
I think that, well, again, that's the reason why we think you need a specialized regulator. Yeah, you'd have to both have technical specifications for the APIs and how they would sit on top of the platforms. And you would probably have to regulate the business model, because the platforms are not going to give up their ability to do targeted ads to these new filters, voluntarily. I mean, to some extent.
As a technical, I have one more technical question, sorry. But
Yeah.
with these, let's say there's 2,000, and you may be talking many orders of magnitude greater, but I'm just trying to understand, would these 2,000 all get like, would they be all sort of approved by the government? Who would decide who these 2,000 are?
Yeah, so I think, you would need a regulatory regime that would set certain minimal standards, right? So they couldn't promote violent material. I mean, the sort of stuff that the platforms used to do before they got into this political role, there would probably have to be certain minimal standards that they would have to meet. I think that, there needs to be rules about the business model, because it's not clear that there's an incentive to create these kinds of companies if the platforms are not forced to share revenues or pay fees and that sort of thing. But yeah, so this is not something that's going to happen. If it could happen spontaneously, it would have happened already. And the fact that it hasn't means that I think you do need a kind of regulatory regime to enable them to, to come into existence.
This is on a slightly related or slightly different topic, but I find a pretty interesting question. This is from Rohao Lee. I apologize if I mangled your name. In today's stock market infrastructure, a company like BlackRock, with its $7 trillion backing, often has interest impact control in multiple major companies across an industry. For example, in the past 1 to 2 years, BlackRock has pushed for more environmentally friendly agenda, and it is cited and criticized as BlackRock pushing a political agenda where the US won't. Well, I support this particular environmentally friendly initiative by BlackRock. How worrisome is it for major funds like BlackRock and Vanguard gaining an interest in pushing their agenda?
Be still my heart. I love this question. Very brief. Section 8 of the Clayton Act prohibits interlocking directorates, which is an early form of this kind of concern, and I think it needs updating to reflect very powerful, and I love this example too, very powerful growing evidence of common ownership actually playing a quasi-governing role in our society. So it basically prohibitions against forms of common ownership that lead to behind-the-scenes control, I think are really critical. It's not just the upfront fractures.
On a slightly different note, I just want to point out that this is one of the examples of quite common schizophrenia we have about the role of corporate power in politics. Back to my example about, well, when corporations do good things, they're good corporations, and when they do bad things, they're bad corporations. Corporate campaign contributions are bad, but when they support Colin Kaepernick, they're good corporations. I think that's an irreducible schizophrenia unless we stop thinking of corporations as having really important political roles. And I think antitrust, anti-monopoly is a really good way to put that genie back in the bottle so that we can stop just cheerleading for this corporation over that corporation in the political sphere.
Okay, this one comes from Sam Shapiro. Assuming that certain business models like targeted ads are bad, is making that business model illegal better than a free market solution? There are alternative companies that can compete by having a policy of not using targeted ads. Is it unrealistic to think that as a consequence of this business model are now increasingly in the spotlight, consumers will be more informed and have the opportunity to choose between browsers, search engines, and platforms that have more appealing privacy standards?
Yeah, well, that's been the hope that these platforms would start competing on things like protection of privacy. It just hasn't really worked terribly well because they really do find it very profitable to violate your privacy, and it's very hard to see. Well, and I guess the other problem is there's really a problem with consumers themselves undervaluing privacy, partly on the basis of ignorance. I mean, they don't understand the extent to which Facebook and Google have already found out where you live, where you went for lunch yesterday, all these sorts of things. Maybe if they knew that better, they would worry about this a little bit more. But there have been a number of empirical studies that have tried to measure how much people would pay to have their privacy protected. And, essentially most people give it away for the, for the free email account or for the, access to a particular website. So I think that, it's one of those things that if privacy were that important and there was a market for it, it would have happened already. And the fact that it hasn't means that, there's a market failure there.
Except what we know about Instagram and Facebook is that before Facebook purchased Instagram, they were competing on privacy and then they stopped. There's wonderful work by Adina Srinivasan on showing exactly that. So that at least a breakup allows for the possibility of competition. I actually really agree with Francis that it's not going to be sufficient, but we're not even trying right now. Like until you break up Facebook, you don't see competition. And just to reiterate the point, Facebook used to compete publicly on privacy and it stopped after its acquisitions of potential rivals. So this is the argument for competition. Having said that, I think it's more like addiction. Like you can, if you don't outlaw the business model, like it's very similar to gambling, that there are reasons that we limit the amount of gambling in a society because people have the choice not to gamble. They are well educated about the social costs of gambling. And yet our brainstem is just not designed to withstand that temptation.
Great. We're a little bit over already, so I'm going to wrap us up. But thank you so much to Nolan, Francis, and Zephyr. This was a really wonderful conversation. I believe it was being recorded, so it should be up on the Stigler Center's website later. So if you want to rewatch, thank you all for joining us.
Thank you.
Thank you so much.